So hi everyone and welcome to today's live Q&A session. So today we will discuss special guardianship orders. So really looking at what they are and what your rights and responsibilities are under an SGO. We have two members of our family law team with us today. So we have Director and Solicitor Sophie Raymond and I believe caseworker Charlie Guest from our family law team. And they will be giving you advice and answering your questions today. We will also be answering any questions we receive from the chat box, so leave us any inquiries you have below, and our team will answer them for you towards the end of the Q&A. So Sophie and Charlie, can you please introduce yourself and start us off?
Of course, thank you. So my name's Sophie Raymond. I'm a director and solicitor based in the Luton office of the firm, and I mainly conduct work in childcare proceedings and all aspects of family law proceedings, save for divorce and finances.
My name's Charlie Guest. I'm a caseworker at the Birmingham office in Duncan.
So we'll start by answering the questions that were advertised for the podcast, for the Instagram live session, and then we'll answer any questions at the end.
The first question that we have is, what is a special guardianship order?
So a special guardianship order grants parental responsibility to a carer who is known to the child but is not their parent. So for example, a family member such as an auntie, uncle, grandparents, or to friends that are close to the family and the children have a relationship with. Also to foster carers once they've been in the child's been in their care for a specific period of time. The order is designed to place the child in their long-term care and are governed by Section 14A of the Children Act 1989.
How do you become a special guardian?
So there are a few instances where this could happen. Usually it's within care proceedings whereby the parents who are not able to care for the child put forward a family member to be assessed. So the local authority are therefore already aware of this because they've been given notice by the parents. But alternatively, there's private law proceedings too, which can be issued, and the local authority must be put on notice 3 months prior to any application being made. So once that notice period has passed and the application is made, the individual must be assessed by the local authority to ensure that they can care for the child. The assessment's quite an in-depth process, and it looks at the special guardian's own childhood, education, jobs they've completed, social care involvement, if any, their home conditions, any health conditions they have, and whether they would impact on caring for the child, and their relationship history as well, just to obviously make sure there's been no domestic abuse, or if there has been, the appropriate courses and action has been taken. References are also required from family members, friends of the potential special guardian, but this isn't an exhaustive list. So they obviously assess and look into many different things. For example, they also look at the pets that live in the home. So they do assessments of dogs, for example, to check that the dogs are safe to be around the child.
What are the responsibilities of a special guardian?
So the order allows the special guardian to care for the child as a parent would. So they are granted parental responsibility so that they can make day-to-day decisions for the child regarding their care. This includes decisions regarding schooling and their health. Special guardians should always consult the parents when making decisions where possible. But if this isn't possible, the special guardian does get to make the final decision. So obviously, if this becomes a disputed issue, then they can't agree, then they would need to potentially return to court for specific issue orders or prohibit steps orders if it's a really contested issue. So the parents also retain their parental responsibility once the special guardianship order is made. So that's why they need to be consulted. And it's also the special guardian's role to keep the child safe throughout their minority.
And how long does a special guardianship order last?
So the purpose of the order is that the special guardian cares for the child for the duration of their minority. So their orders made by the court are not intended to be short-term orders. So the order usually lasts until the child's 18th birthday.
And can you discharge a special guardianship order?
So yes, you can discharge a special guardianship order, but you do have to make an application to the court for permission to apply to discharge the order first. The court will then consider whether significant changes have been made and sustained by the applicant. If they have and there is evidence of the same, the court may grant permission to apply to discharge the order. So, for example, if a parent has struggled with substance misuse and mental health issues, and has now taken some time to engage with drug and alcohol services and medication through their GP and counselling services. And obviously, they've managed to make big changes in their life, and they've managed to sustain those changes, and a significant period of time has passed would have evidenced that. And they've got hair strand testing results, which is clear for drugs and alcohol. And they've got letters from their GP. And potentially any counsellor or therapist, then the court may decide to grant permission to apply for the order so they can look at this in detail. So if they do, if they have made changes and there is evidence of the same, then the court can grant permission to apply to discharge the order. So then the application will be heard by the court, and further assessments, as we've spoken about earlier, will then be completed by the local authority. And if the assessments are positive, then the court may make an order to discharge a special guardianship order. So they're all of the questions that we had prepared today to be answered. But if anyone has any questions, please pop them in the box and we will answer them. Alternatively, you can get in contact with us by email if you do need any assistance in relation to special guardianship orders.
Great, so thank you both so much. That was really informative. I believe we don't have any questions at the moment, so maybe we can just wait for a few minutes to see if anyone has any questions for us.
Yeah, of course. I'll talk while we're waiting. I'll just talk a little bit about funding as well for special guardianship applications through legal aids. They are to discharge. I'm going to speak about. So you would need to. So it is merits tested in that you would need to evidence changes, and show that you've sustained them. So we would have to when making an application to legal aid, we would have to set out the changes that have been made, what services have been engaged with, what testing's been completed, because the legal aid agency could say that there's not merits to this application, and essentially it would be a waste of public costs. So we have to make sure, obviously, that we justify any reason to discharge any application. And similarly, with applying for a special guardianship order, I've represented grandparents and aunties and uncles in the past that have applied for those orders. Again, it is means and merits tested, so we just have to justify why those orders are sought. And with the special guardians as well, we set out, if they've had a negative assessment, why they are challenging that assessment and why they feel that they do have merits for their application. So it is possible to get legal aid, but you do need to obviously meet the merits test in order to get that. It's not automatic like care proceedings.
Great, thank you so much, Sophie, for explaining that. So it looks like we are not getting any more questions. So thank you both for explaining what special guardianship orders are and sort of answering the frequently asked questions that I'm sure you both get. We'd also like to say thank you to everyone who's joined the Q&A today, and to Sophie and Charlie for their time and for sharing their very valuable insights. If anyone has any questions or they need more advice, you can contact Duncan Lewis at the number in the chat box. You can also email Sophie and Charlie directly. Their emails are also in the chat box. The Q&A has also been recorded and it will be posted on our social media shortly. So you will be able to rewatch it again along with our other Q&As. So thank you all for joining us today, and we hope you found this session helpful.
Thank you so much.
Thank you.